Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukra. Ethics class. Simple point. Whether consumer court can entertain plea of deficiency of service on the part of advocate, whether it is a service of contract or whether it is a personal service for contract. This is a question which we are going to tell. Of course, in the classes, number of cases I have told you that the advocate can be taken to the consumer court as per Savitri versus State of Tamil Nadu, if I am correct. Likewise, it cannot be taken to the court. Now we are going to discuss that case law. The case law is Bar of Indian Lawyers through its President Jasbir Singh. Jasbir Singh Malik versus DK Gandhi PS National Institute of Communicable Diseases. This is Civil Appeal number 2646 by 2009, decided on 7/11/2024 by Honorable Justice B.R. Gawai. Today we heard the news that he is going to become the next Chief Justice of India. Justice B.R. Gawai and Vishwanathan as well as Prashant Kumar Mishra, who worked as our Chief Justice of Andhra Pradesh. 3 judges bench. They clearly held that legal profession is not covered under the Consumer Protection Act 2019 also. Section 2, Clause 24 of the Consumer Protection Act 2019 defines what are the services. Please remember, services rendered by lawyer, they are not services for contract. They are service of conduct. Legal profession is different from the other professions. It's a noble profession. It's a 25/7 profession, and the result is not guaranteed by the so-called arguments of the advocate. It is for the court to decide. So, main point is whether the legal services can be taken to the consumer court or not. 100% no. This is the reply, and you have to stick to it also. Right. Normally, in the case of Indian Medical Association versus VP Shanta 1996, I told you what is a profession, what is an avocation, who is a professional, who is having the so-called specialized knowledge, specialized training in the particular field. They are called professionals. And if the hospital doesn't charge any money, no consumer case. And if the hospital charges money, definitely they will come under the Consumer Protection Act. That is as far as the medical people are concerned. Right? Whether the case can be filed for deficiency of service by the advocate or not. So, now let us go to the facts of the case. That's better. Jasbir Singh Malik is an advocate. Right? His services were taken by DK Gandhi Institute of Communicable Diseases to file in case of NI Act 138 Negotiable Instruments Act, that is Check Bounce Act, against for 20,000 against one Kamal Sharma. So actually Jasbir Singh Malik is supposed to file a case of NI Act before 30 Hazari Courts, Delhi, for the failure of this man Kamal Sharma to repay the money or for giving a check which is bounced. The matter, yes, was allowed. CC number was given. The matter is going on, but in the interregnum period, they have effected compromise. The other people, that is Kapil Sharma, he has gone back the 20 lakhs and also 20,000 and also 5,000 towards compensation. But this amount was not given to the client by the advocate. This is the allegation. Right. Moreover, this advocate filed a small causes suit. That is in the court of small causes. For 5,000 rupees, he has filed a case towards the adjustment of the lawyer's fee. ఆ డబ్బులు ఇవ్వకపోగా పైగా కేసు వేశాడు. దిస్ అలిగేషన్. సో దేర్ ఫోర్ దెర్ ఇస్ డెఫిషియన్సీ ఆఫ్ సర్వీస్ అని చెప్పి కన్జ్యూమర్ కోర్టులో వేశారు. లోవర్ కోర్టు కూడా యాక్సెప్ట్ చేస్తుంది. బట్ ద ఫ్యాక్ట్ ఈస్ దట్ హీ హాస్ టేకెన్ డిమాండ్ డ్రాఫ్ట్ డీడీ తీసి కంప్లైంట్ పేరుతో ఇచ్చాడు. కానీ అతను దాన్ని ఎన్కాష్ చేసుకోవాలి. 20,000 అతనికి ఇచ్చేశాడు. 5,000 యాక్చువల్గా మనోడు కొట్టేసినట్టున్నాడు, చెప్పలేదు దాని లెక్క. సో దానికోసం ఇప్పుడు కోర్టులో కూడా వేశాడు. ఇదేమిటి, నాకు ఇచ్చిన 20 లక్షలు 20,000 రూపాయలు నాకు ఇవ్వకుండా మళ్ళీ పైగా నా మీద కేసు వేస్తాడా అని చెప్పి హీ హాస్ ఫైల్డ్ ఏ కన్జ్యూమర్ కేస్. దిస్ కన్జ్యూమర్ ఎవరు, డీకే గాంధీ వరల్డ్ ఇన్స్టిట్యూట్ కాబట్టి వాళ్ళు వేశారు. వేసిన తర్వాత ప్లీజ్ రిమెంబర్ DCDRC, that is District Consumer Disputes Redressal Commission, they found that yes, the lawyer there is deficiency of service on the part of the lawyer because he has taken the money. Already మీకు చెప్పాం, when you take the money, rule number 16, 17లో కూడా డిస్కస్ చేస్తాం. when you take the money, definitely you have to hand it over the client. It's a failure, it's a professional misconduct. Second, so now this man went in appeal. State commission, yes, they allowed the appeal, stating that lawyer services, they do not come under purview of the consumer court. So once again the matter went to the appeal to the Supreme Court. Actually, even though they have got done number of cases, they have appointed Mr. V. Giri as amicus curiae and ultimately decided the matter on 7/11/2024. So please remember, legal profession is a noble profession and the autonomy should be preserved for making the strong judiciary. So please remember, if you allow the consumer court to take up cases against the advocates, it is nothing but opening of the floodgates of unnecessary litigations. And reliance was placed on R. Muthukrishnan versus the Registrar General, High Court of Tamil Nadu, High Court of Madras, 2019. Very beautiful judgment, 10 points they have given. So likewise, here they have clearly stated that lawyers do not come under the purview of Consumer Protection Act. If you remember, this much is sufficient. So please go to the case law and enrich your legal knowledge. Thank you very much.